Whether you've applied for benefits or not, you might be curious as to how Social Security makes a determination of disability. Let's talk about that. The first thing I want to do is read to you the statutory definition of disability. Congress passed this law, and this is how the U.S. Congress defines disability for an adult. An individual shall be considered to be disabled for purposes of this title if he is unable to engage in any substantial gainful activity by reason of any medically determinable physical or mental impairment which can be expected to result in death, or which has lasted or can be expected to last for a continuous period of not less than 12 months. Well, that's a very long definition. But what Social Security has done is they've taken that statutory definition and turned it into 5 questions. It's known as the 5-step sequential evaluation process. And at every decision-making point in the process, Social Security asks these 5 questions. So when you initially apply, and then if you appeal your initial denial and you're at the reconsideration level, or if you're in front of an administrative law judge or the appeals council, it doesn't matter. At every level, these 5 questions are asked. So what's the first question? The first question is the claimant able to work? That's also known as, is the claimant performing SGA? The second question is, does the claimant have a severe impairment? The third question is, does the impairment meet or equal a medical listing? The fourth question is the claimant able to perform prior work? And the very last question is the claimant able to do other work? So let's go back and talk about each of these questions. The first question is the claimant working? If you're able to work full-time, 40 hours a week, 5 days a week, 8 hours a day, then regardless of your medical condition or diagnosis or prognosis, Social Security will not find you disabled. There are exceptions to SGA, such as sheltered work or subsidized work or maid work or accommodated work. That means that some people are working full-time, but they're working at a job that really doesn't exist in the competitive economy. Sometimes friends help them out, family members help you out, and you're doing something that's not a real job. That would be an exception to SGA, and if you can provide evidence of that, Social Security might still consider that you're not working substantially and move on to the second question. There are separate rules that apply to you if you are engaged in self-employment. There's also an amount, a monthly gross earning, that is considered substantial gainful activity. In 2010, it's $1,000 a month gross earnings. For 2009, it was $980. For 2008, it was $940. Between the years of 1999 through 2000, it was $700 a month, and then after that, Social Security increased SGA minimally every year. We can expect to see more increases for 2011, 2010, or 12. Let's talk about the second question. Does the claimant have a severe impairment? This is considered a threshold issue. All the claimant really has to establish is that they have an impairment or medical condition or a combination of medical conditions which significantly limit the physical or mental abilities to do basic work activities. So here's an example of what that means. Let's say you are a truck driver and now you have diabetes. Let's say you are insulin dependent. It's going to be very difficult for you to continue doing long haul trucking with your diabetes. Insulin dependence means that you're going to have a sterile environment for your needles. You're going to have to take frequent breaks to check your blood sugars and to give yourself your insulin, as well as to eat regularly. All of those things can be inconsistent with truck driving. So a person with a diagnosis of diabetes insulin dependent, even if their diabetes is under control, is usually going to be able to establish that they have a severe impairment. That's just one example of severity. It is considered a fairly easy test to overcome. Judges often will, or decision makers will often deny an individual at step 2 when they feel that the medical conditions are not significant. But so long as you're able to establish that your job is affected by your medical condition, then you can get past step 2. What about step 3? Social Security has a list of medical conditions that they call impairments, which are arranged by body systems: musculoskeletal, skin, endocrine, neurological, mental, cancer, immune system, so on. If you have a condition which is the same as, or if your medical records establish medical findings that are the same as the medical findings in the listing, then you can meet the listing. You can equal the listing if your condition is very similar, or you have other findings which are just as significant even though they're not listed. In general, it's very hard to be found disabled at step 3. It's very hard to meet a listing because the listing criteria provide very significant problems. So let's assume that you are not working, so you get past step 1. You do have a severe impairment, you get past step 2. And you have medical conditions which are listed, but they're not as severe as the listing requirements, so you are going to go past step 3. The next question is, can the claimant return to prior work? Essentially, Social Security will look at jobs that were performed in the past 15 years, long enough for the individual to have learned how to perform them. So if you did a simple job that only took 3 months to learn, and you did the job for 6 months, that job would count. If you had a very complicated job, very highly skilled job, and one that takes several years to learn, and you only did that job for 1 year, that job would not count. So Social Security looks at the jobs you did in the past 15 years and decides whether you can perform those jobs given your medical conditions, the limits due to your medical conditions, as well as the abilities that you continue to have. So let's assume you're not working, step 1. You have a severe impairment, step 2. You don't meet a listing, step 3. And you cannot return to any of the jobs you did in the past 15 years, step 4. The last question is, can the claimant perform other work? Social Security looks at jobs that exist in the national economy and the regional economy. Social Security will not find you a job in your hometown, but they will look at the availability of jobs in the regional area, in your state, and so on. Social Security will look at what you can do and what you cannot do due to your medical conditions and determine whether other jobs exist. Now, a good way to establish that you can't do other jobs is to get an opinion statement from a treating doctor. A treating doctor who can provide information to Social Security on how much you can lift or bend or stoop, concentrate, get along with other people, whatever your medical problems are. Assuming your doctor's opinion statement is consistent with his medical records, Social Security may be required to give that opinion statement significant weight, and it may result in a decision of disability because no jobs will exist in the national economy. Those are the 5 steps that Social Security uses to determine disability.